Hi, I'm attorney Renee Osipov with Chelle Law, and we assist families, specifically parents, guardians, or students who are having issues surrounding 504 plans. In this video, I'm specifically walking through the timeline of a 504 plan. How long does it take from the time that a parent requests to the 504 plan and the accommodations being drafted, and how long those accommodations are good for. So this is a video that's walking you through the timeline of the entire process. So before we get started, I just want to go over a couple of things. 504 plans are codified in federal law, specifically the Rehabilitation Act, Section 504. So that's where it comes from. If you think a student qualifies for a 504 plan, they have to have some type of physical or mental impairment that substantially limits a major life activity. So that would be something within the confines of the school itself, or getting to and from the school, but it would have to do with something within that school day, in that environment, that they are substantially impaired and that it's limiting these sort of like life events, which would be education. So if you think that the student or your child would qualify, before you start the process, before we even start this timeline, in my opinion, I really do recommend that you first take the child to a healthcare provider, therapist, primary care, or some type of specialist to actually get that diagnosis first of the impairment before you start the process. Because if you don't, 504 coordinator or team could, first of all, it could take a lot longer, and the student could be found ineligible. So before you even start, if you think the child has an impairment, go get a diagnosis first. Then let's start from there when the clock actually starts. Now, one thing to remember is that 504 plans and IEPs, some people think they're interchangeable. They're not. They do have some overlap. But the thing with an IEP is there's very strict deadlines for when the school must comply. So respond, evaluate, all of that. 504 plans, the requirements are a little bit more vague. So we're going to go over what the law actually says and then generally what's the requirement. And then at the end of the video, I will go into, if you feel like the school is violating this, they're not complying, I'm going to explain to you how to report the school. So first, we have the diagnosis of the student. The parent feels like they are impaired or substantially impaired within the classroom, and so they are ready. They want to ask for those accommodations for the 504 plan. So always, always, always do this in writing. I would send a certified letter as well as potentially maybe an email to multiple members of the staff, but I would send a letter, an official letter, certified in the mail to the school so that no one can later say, oh no, we didn't know that you needed one, and then the clock would then restart over. So if you want the clock to start and you're very serious about getting your child those accommodations, you want to send in a certified letter. That's what I would do. Now, the time frame in the federal statute just says a reasonable time from receipt of the initial referral. So that's going to be the letter when you're asking for them to be evaluated for a 504. Now, generally in most states or schools may have a policy, it's around 30 days. So I would recommend sending in a letter, and if you don't hear back by the school within 30 days, then we have a problem, and I would reach back out to the school and try multiple times. And again, I will, at the end of the video, I'm going to explain how you can enforce this timeline. So the law says reasonable from the time of the referral. So 30 days is generally considered reasonable. If you haven't heard back from the school, honestly, within 2 weeks, I would probably start giving them a gentle nudge and reaching back out. Now, after that happens, they have 30 days to then compile the 504 plan evaluation team. So at that time, they're going to look at that meeting. They're going to look and see what the diagnosis is. They're going to look at data within the school. This could be grades, could be medical information, could be observations of teachers and other staff. all of this data, they're going to look at it and they're going to see if there actually is a substantial impairment. They're going to make the deciding factor on if the student then qualifies. This initial meeting for evaluation, again, it says within a reasonable time, but generally this is another 30 days. So you get a referral, and at this evaluation meeting, it's going to be normally 30 days out to make that progress, to check and see if the student is actually eligible for accommodations. Then at the eligibility determining meeting, this gets a little confusing because sometimes the eligibility determining meeting and the initial evaluation meeting, so determination and evaluation are two separate things, but the majority of the time they are together. And this is within 30 days of your referral. They're going to take this information, they're going to make a determination. If they determine that the child, the student, is eligible for 504 plan accommodations, then we're going to move forward to the developing meeting. So the developing meeting is whenever the team is going to all come together. Now, important thing to remember about this, parents are part of this team, or guardians are part of this team. This could also mean other staff members, therapists, other types of healthcare providers, coordinators, lots of people. So sometimes this is hard to coordinate this whole group to come together for this meeting. So it can take a little bit longer occasionally, but you want to make sure, again, the key word, the key phrase in the law is a reasonable period of time. So again, this is normally held at the very least within 30 days of the determination. So we've determined that the child is eligible for the 504 plan accommodations, and within 30 days, it really shouldn't be over 30, then the group needs to come together to discuss what type of accommodations should be included. Then the IEP is drafted and it's implemented. So then the child would receive all those accommodations, everything looks great, and we are up and running. So just to review, from the time that you request an evaluation, it's 30 days. The school then has 30 days to evaluate the student. And then we have 30 days from that to actually determine eligibility. Now, those sometimes are at the same time. Then 30 days to then go ahead and have the team assembled and draft that letter. So as you can see, there are many steps to a 504 plan, so it can take a long time. So if you're really concerned about your student, like I said, you need to get immediately, you need to get a diagnosis as soon as possible. You need to refer as soon as possible. And any delay in that process is going to take even more time. So again, the legal standard is reasonable period of time, but just to remember, keep it in your mind, it's 30 days, each step. And so you want to keep reaching out to the school. You want to keep communicating because you don't want to get lost in the shuffle, because it takes a lot of time and there's a lot of people to assemble. So you want to make sure that you are in continual communication with the school and your request. Now, we are to the process. The 504 plan is in place. Everything is great. Then at that point, every year there should be a 504 plan meeting. So they're just going to basically discuss, do they feel like the student is still eligible? Are these accommodations working? Does anything need to be amended? Does anything need to be removed? It's a time to meet together and just really progress monitor and see how the student is doing. So that is required every year. And then every 3 years, then the student is up for re-eligibility. So at the 3-year mark, the school is going to, or the team is going to come together and they're going to make a determination at that time. Is the student still qualifying for a 504 plan? And then this whole process just continues on until the student is done with their secondary education. Other videos I've kind of explained this, but accommodations can follow the student even at the university level. They're not normally called a 504 plan. The universities have there's lots of different names for the accommodations, but it can actually go all the way through their whole educational career. But as you can see, like I've said before, 30 days from each of those initial steps can take a long time. So if your child is really suffering in school, you want to ask for a 504 plan as soon as possible to get the ball rolling. Now, I also stated that I would explain how to enforce this timeline. So the reason why I say you need to send an official letter with certified mail is so that we have a record of the communication with the school. If you feel like the school is not complying with this, they're just completely ignoring you, or you feel like this is very unreasonable. So if it's been 3 months, you've been reaching out to the school, asking them for eligibility for 504, and they are just dodging you, and it's been 3 months, what do? So I would first let the school know that you are intending to file a complaint. Sometimes that will be enough to get them to realize that you're serious and that they need to comply with federal law. Sometimes they don't, even then, and we won't get into if we think this is an ill will or if this is just an oversight, because that's really the school's responsibility. That isn't the parents. And I always want to remind them of that as well. Don't feel bad for holding the school accountable. They know the rules, or they should know the rules. It's their job. If they have continuously delayed the process and the time that they have delayed is unreasonable, you can file a complaint, or you can have an attorney do it for you. We do this here at our firm. You'll file a complaint with the Office of Civil Rights. So this is actually a federal agency. This is not a state agency. So I think one confusion here is that parents think that they can report the school to their state board of education. You can do that for IEPs, but 504s actually need to be reported to the Office of Civil Rights, because essentially what you would be alleging or claiming is that your child has been discriminated against because of their disability, because they're being denied accommodations in the 504 plan. So if you go to the Office of Civil Rights website, there is a way to make a formal complaint against the school. Like I said, though, you want to show that you have a timeline of communication. But if you have any additional questions, you can check out our website at Chelle Law, or all of our contact information for our 504 specific website are in the description below this video. We have lots of other videos on there. Also, you can set up a consultation, and we're happy to walk you through the whole 504 process, or if you're needing to file a complaint.